Session, the Honorable Judge McEnany presiding.
Still plenty of seats in the front.
Thank you. Please be seated. Good morning, everyone. Welcome to the April docket of the Kansas Court of Appeals, sitting at Johnson County Community College. It's our pleasure to be here. As you know, the Kansas Court of Appeals is a traveling court. We like to get around to various communities to hear cases, and we always try to hit Johnson County Community College at least once a year in the springtime, so that the students and faculty have a chance to see and members of the community have a chance to see their court in action. We have a number of cases set on the docket this morning. As I was introduced, my name is Patrick McEnany. I'm the presiding judge, which means essentially I just keep track of time. That's pretty much it. I'm formerly a district judge here in Johnson County. To my right is Judge Steve Lieben, who is also formerly a member of our court and formerly a district judge in Johnson County. And to my left is Judge Kim Schroeder, a member of our court who was a district judge in Southwest Kansas before coming to the Kansas Court of Appeals. I think the lawyers pretty much know the drill, but for the benefit of everyone else, I will remind you that first off, we have reviewed your briefs. We have a pretty good handle on the facts. If you wish to jump right into your argument, please feel free to do so. That is our typical situation. In view of the fact that we have a number of students here, it might be helpful if you do, though, give a brief outline of the essential facts for their benefit. We've provided the students with summaries of the facts and the cases in advance, but time may have worked its magic, and that may be all in the past, and they have forgotten about that. So remind them if you would. These cases are set for argument 15 minutes per side. If you're the appellant, please let me know if you want some rebuttal time, and I'll do my best to keep track of that for you. When you come up to argue your case, please announce who you are and who you represent, so I can keep track of that and have a record of exactly who is here arguing the case. Our first case for argument today is Howard Johnson III versus U.S. Food Services and American Zurich Insurance Company. Appearances, please.
Please the court, my name is Mark Kolich. I represent Howard Johnson. Michael Wallace is with me. He also represents Mr. Johnson. And essentially we're appearing on behalf of all injured workers in the state of Kansas at the present.
All right, sir. You may proceed.
And I'd like to reserve 2 minutes, Your Honor.
Got it.
Mr. Johnson was a delivery driver employed by U.S. Food Services. On October 16, 2015, he suffered a work injury involving his neck. It resulted in 2 herniated discs that compressed his spinal cord, causing symptoms that affected his ability to walk. Surgery was necessary. He came under the care of Dr. Harold Hess, a board-certified neurosurgeon. Dr. Hess performed a 2-level fusion after removing the damaged discs. Basically, he used bone from a cadaver, and he put it between the disc bases and then used metal plates and screws for stabilization. Mr. Johnson missed work. He was off work about 6 months. He worked hard on his rehabilitation, and he has been able to return to his former job. However, he must modify the manner in which he does things because of the residuals from his injury.
Did he have work restrictions?
He was released without restrictions.
Okay, so when you said he must change the manner in which he does things, I'm not sure what you mean by that.
Well, restrictions, I think Dr. Hess explained, restrictions are imposed to give some advice to an injured person on what activities should be avoided and to avoid or prevent re-injury, whereas limitations are different. They're not necessarily restrictions by a doctor, but because of changes in your physical structure of your body, you are now limited in performing certain things.
But is there any testimony that he's unable to do any job-related task that he previously did?
No.
Okay. Does he have any award for future medical?
Yes.
What is that award?
The award is simply future medical is available to him upon application to the director unless the parties can make an agreement on additional treatment being provided.
Well, what would he have to prove to be able to get it? I mean, my understanding from the record is he has some chance of needing further surgery, but it's not more likely than not. So legally, what situation is he in under the current act in terms of having a right to future medical?
Well, I believe there's more than just what you're alluding to, Your Honor, is the probability of additional surgery because of adjacent segment breakdown, because of the advanced degeneration on adjacent segments because of the fusion. There is also testimony.
He doesn't have any current award that would let him get that automatically, right?
No, unless the employer agreed to send him back to the doctor, we would end up in front of a judge again.
Okay, and what would you have to prove to be able to get a further operation treated?
We would have to prove that it is at that point necessary and that it relates back to the original injury.
And is there anything different about that test now than there was before 2011?
Yes.
What's the difference?
2011, in 2011, first off, it was automatic. You got future medical just when you tried the case. You did not have, now you have to prove that future medical treatment is a probability because of the accident.
But you proved it was a probability?
There was evidence that it was probable. Not necessarily the surgery. The surgery's wasn't the whole thing. There was other evidence that it's probable that he will need conservative measures because of his injury. I think, Your Honor, under the current statute, we don't have to prove at the first award the nature of the future medical, just that future medical of some sort will be probable.
Okay.
We went to trial in the case regarding the issue of this gentleman's entitlement to compensation for permanent disability compensation. He was awarded compensation for a 6% permanent partial impairment to the whole person, and as a consequence, he was awarded approximately $14,800. Had he been hurt 11 months earlier, he would have been awarded compensation for a 25% impairment that would have been worth almost $62,000. That is the reason we are here. It is our contention that this reduction, which is due to a statutory amendment, is unconstitutional. In particular, the statutory amendment came into effect on January 1, 2015. All injuries on that date and beyond are governed by the 6th edition of the American Medical Association Guides to the Evaluation of Permanent Impairment. Call them the guides. Before, for any injury that happened before that date, the 4th edition was used, and it was used for a number of years.
When you say a number of years, how many?
Well, I think, I don't recall the exact dates, but I think it dates back to, I think we started with the 3rd edition revised for a couple years, and then it went to the 4th edition, and I believe that started in 1993.
So it had been in place approximately 20 years.
Yes.
When you say that you're challenging the constitutionality of this change in the statute because it has reduced your client's award from about almost $62,000 to about $15,000.
Yes.
Are you claiming that the statute is unconstitutional as applied to your client, or are you claiming that that on its face the change in the statute is unconstitutional as applied to everybody, every injured worker who makes a claim?
Well, I can't say that every individual worker is adversely affected by the guides because I don't know all the circumstances of every claim, but I would say most likely that's true. In fact, there is another claim pending before a different panel of this court, Pardo versus United Parcel Service, that involved an injury to the shoulder where use of the guides actually prevented any recovery at all.
Well, I understand, but you say it's likely true. I guess I'm trying to understand what you're actually claiming. Is it your claim that it's unconstitutional on its face as it applies, that no one, everyone is denied a valid remedy? Or are you just saying that you're here advancing the cause of your individual client, saying that it's unconstitutional as applied to him?
I cannot definitively say that it would adversely affect every claimant.
Okay.
But I can say without reservation that it adversely affected Mr. Johnson, and it's also clear that Section 18 of the Kansas Constitution guarantees a recovery to all persons. It is not limited to the population in general.
But I want to be clear on what remedy you want us to enter for you.
Okay?
There's a combination of things going here. We have the amendments that were made in 2011 that resulted in some reduction in what most workers would recover under the Workers' Compensation Act for an injury.
Oh, I'd submit it's more than some reduction, but yeah, I agree.
A reduction of unknown amount.
Okay.
And we then have the change in 2015 in which there's a further reduction.
Yes.
And I think your claim is that the combination of the 2011 changes plus the 2015 change result in a overall recovery that is now so low as not to be a fair substitute remedy for a tort suit.
That is precisely what I'm arguing, yes.
Okay. So it seems to me that the legislature could choose to fix that by changing some of the things they did in 2011, or they could choose to fix it by a bill similar to the one they rejected in 2016 to go back to the 4th edition. What is it that we should be doing here in your case? Do we simply declare the law unconstitutional as applied to your client? Do we say it's unconstitutional generally? Do we say you go back to the 4th edition? Do we say you go back to the pre-2011 Act? I don't know what it is we would say, given that these two things really act in combination.
They do act in combination, but, and the case law indicates that the Workers' Compensation Act is to be viewed as one unit that's a system for restoring people the economic loss due to a work injury. What I am proposing is that at this point, I would like nothing better than for the court to strike the 2011 amendments too, because I think on their face they're unconstitutional. But those did not really affect Mr. Johnson. For instance, prevailing factor, which I think is a horrible standard that we're imposed with now, that didn't affect him. He was able to collect compensation. His compensation, however, was very limited by the 6th edition. So what I'm proposing is strike the 6th edition, and there's an easy way to fix it, and that is when the legislature changed 44510D, which is scheduled injuries, and E, which are body as a whole injuries, they forgot to amend 44508 subsection U, which is a general definition of permanent impairment. They left that to be measured under the 4th edition. So we have a conflict there. So my proposal would be strike the 6th edition as unconstitutional because it's not an adequate remedy, an adequate substitute remedy, and go back to the 4th edition. The 4th edition wasn't perfect by any means, but it's much more fair than the 6th.
When you talk about, for example, that the prevailing factor test doesn't adversely affect your client, but does adversely affect many others.
Yes.
We also have the situation that the whole work comp scheme is designed to let you have a recovery even though you don't have to prove negligence. So one of the reasons it's an adequate substitute remedy is that we don't make you prove the liability of the employer, you just go directly to getting a recovery.
But that's not exactly true anymore either. Although a claimant doesn't have to prove negligence, the legislature has imposed fault as a defense. For instance, 44501, the very first section of the Workers' Compensation Act, before 2011 used to say, this is the Workers' Comp Act, employers have an obligation to provide benefits to injured workers. Right now, 44501 says this is what's not allowed. Before they even establish a right, they say this is what precludes you from getting benefits. And the big thing is a drug defense. And if you have a post-injury positive drug screen, you can be denied, based on presumptions in the statute, compensation altogether, even if there's really no correlation between the test results and you being impaired. There's also things, a provision in there that if you don't use a safety device, you lose all benefits. So these are akin to comparative fault, contributory negligence, things that way back when the Comp Act was, had its origin were supposed to have been eliminated, but they've crept their way back into the statutory scheme.
You're about out of your immediate time.
Okay, well-
You're bumping up against your rebuttal time.
Well, I'll leave it at that if there's no additional questions. Thank you.
Good morning. May it please the court. My name is Michelle Haskins. I represent U.S. Foods and their insurance carrier, American Zurich, in this matter. As counsel has already alluded to and as has been discussed in the brief, Mr. Johnson was hurt at work, and as a result of that, he received medical care at no cost to himself. He received time off pay, temporary total, for about 25 weeks when he was medically restricted from returning to work.
You agree that that recovery for lost wages is not close to the amount of his actual lost wages, do you not?
That's true. It would be, in his instance, it would be statutorily, he was capped at 2/3 of what he was making. There's a statutory ceiling that applied to him because he earned so well for his date of accident.
Right, so what percentage of his actual lost wages did he recover?
He would have received, he received a compensation rate of $610 per week, Your Honor, and I'd have to look back to see what his average weekly wage was. I think in his case it was over $1,000 a week.
And the 610, then he gets a percentage of that, or that
No,
was-
he gets that
was what he
amount.
got? Okay.
That's what, that would be the.
That was the maximum?
That's the maximum for that date of accident, correct.
Okay.
And that is the rate that is adjusted each year by the legislature to take into account inflation, cost of living, et cetera. So he would have received that while he was medically restricted from working. And then once he reached what's called maximum medical improvement, meaning the doctor feels he can no longer actively advance his physical condition, he has plateaued, Dr. Hess released him.
Under the current act, though, if somebody doesn't reach maximum medical improvement within 3 years, they have to either go to finish their claim or lose it altogether, right?
They have to petition and give good cause for why the claim should still be pending. And if they are under active treatment, that can be one grounds for it continuing.
Is there a guarantee that they get it to continue? The hearing will be continued?
I don't know that that I can tell you it's a 100% de facto guarantee, but I am unaware of a situation where a person that was actively treating was, had their case denied.
Well, didn't our court already uphold one?
I'm not familiar with that one, Your Honor.
Okay.
So at the end of his medical treatment, when he was released at maximum medical improvement, Dr. Hess gave a medical opinion, a rating opinion of 6% impairment, and that was given under the AMA Guides, the 6th edition. Prior to 2015, prior to January 1 of 2015, in Kansas, we utilized the AMA Guides 4th edition in efforts to resolve files. The AMA Guides 4th edition was published in 1993. After January 1, 2015, any injury occurring after that date, we now utilize the AMA Guides 6th edition. That edition was written and first published in 2007. Kansas is now one of roughly 12 to 15 other states, along with the federal government, that do utilize the 6th edition.
And are there other states that have litigated the validity of the 6th edition?
Yes, Your Honor, I believe there are.
And do you know
They
the
have been
results?
affirmed, to my knowledge.
Well, I understood Oklahoma and one other state had not.
Okay, I wasn't aware that that had
I'm not
been
sure of that either
adjudicated,
because
right?
it's-
There was testimony before the legislative committee that Florida and Oklahoma had found this use of the 6th edition unconstitutional.
Okay.
Do you know about that?
I do not know about that.
Well, in any event, I'm a little bit confused on the defense of the 6th edition. Don't we have to look at not just the 6th edition, but the combination of the Kansas Act before they went to the 6th edition, plus the addition of the 6th edition, and in combination now, those still have to provide an adequate alternative remedy?
I would agree.
Okay.
Of course, one of the tests, or the essential test, is that this has to be necessary for the public interest to promote the general welfare.
Right.
I'm wondering, does this legislative shift of the burden of providing for injured workers from the employer to the public at large, while still preserving their immunity from being sued in common law tort, how do you explain that as being in the general public welfare?
Well, in this instance, he still received a recovery. He's just dissatisfied with the amount of money that he received under the 6th. And so the legislature had before it testimony from various committees and various parties, and that's been outlined in the briefs. All these issues were flushed out, and the legislature had that for their consideration before they agreed and voted and moved to the 6th edition. So you were previously using a textbook that was published in 1993. You are now using a textbook that at least was published in the 2000s. So the argument is that medicine has evolved, how we perform our work has evolved, and in this instance, Mr. Johnson returned to work without any permanent physical restrictions, doing his same job, and so in that regard has suffered no additional impairment, and under the guides, under both Dr. Hess's rating as well as the employee's expert's rating, he was entitled to the 6%.
But you've agreed it's not the 6th edition alone that we're looking at. It's the combination of that and the rest of Kansas law still has to provide an adequate recovery. For example, if you said he still got a monetary recovery, if he'd only gotten $10, would you consider that an adequate remedy?
If that was under the AMA Guide 6th edition, that's what we would be left with at this point, Your
So
Honor.
you would consider that an adequate
That
remedy
would
for
be
his
my-
injury?
That would be my argument.
Well, I guess I would say to that, we had testimony before the legislature in their 2016 hearing, or 2015 hearing rather, when they were looking at going back to the 4th edition, by both Secretary of State Kobach, who taught constitutional law at the UMKC Law School for 15 years. He testified that the law as it now stood was unconstitutional. And you had Bill Rich, who's a professor of constitutional law at Washburn University, testifying that the law as it's now combined was unconstitutional. And it would seem to me they're surely right if you got down to a $10 recovery for 2 discs being fused with plates put into your neck, while you recovered at most 60% of your lost wages for a 6-month wage loss and virtually nothing else. Surely that would not be an adequate remedy. So I'm trying to figure out where this line might be if you accept the idea that the $10 actually wouldn't be an adequate remedy.
And Your Honor, I don't know that we can formulate a hard and fast rule, and that is part and parcel of the Workers' Compensation Act. It's an ever-evolving and changing law. Issues of constitutionality were directly addressed by the Supreme Court in Kansas in the Injured Workers v. Franklin file. And in
1990s.
In 1990s. And at that time, the issues that were being argued unconstitutional were stricter notice requirements. The employee had to give notice in a more defined, shortened period of time. They also took the shoulder out of a body as a whole and made it scheduled. That dramatically would have reduced the monetary recovery for someone with a shoulder injury. And those elements were all analyzed under the constitutional arguments and found to be constitutional, and the law was affirmed.
How would it be reasonable in the new guidelines if you had a rotator cuff injury and had surgery? Under the 6th edition, my understanding is you wouldn't receive any award if the surgery restored function. Is that right?
I'm aware that that can be the outcome, yes.
All right.
That would be up to the doctor to testify to, but I'm aware that that could be found, yes.
How would that be an adequate remedy?
Under the AMA Guide 6th edition, the physician would say, when you follow under the diagnostic-based estimates and follow the guide's pronouncements, that is what the doctor is confined to say is the outcome.
Well, I understand it can be on the guideline, but the question is whether the recovery you provide through workers' compensation is an adequate substitute remedy. I mean, you're taking away the worker's right to sue no matter what caused the injury on the workplace.
You're not taking away his right to sue. That worker is still getting the benefits of medical care paid at no expense to himself, lost time, payment for medical mileage
Can he
travel.
sue his employer?
He cannot sue his employer outside of comp,
So
but
that's
he would get
what
the.
you're taking away, right?
Well, you're diminishing his monetary recovery at the end of the case.
Isn't the reason we have to have an adequate substitute remedy because we've taken away his right to sue the employer, his or her?
He still has the right to bring the case. He just doesn't have an automatic guaranteed right to a monetary recovery at the end of the case.
No,
And that
in,
could be
in a tort lawsuit, he or she, the employee, does not have a right to sue the employer for a tort.
Correct.
So we've taken that away, and there has to be an adequate substitute remedy over in the work comp field. Is that not right?
I guess my perspective from it is different from what you're saying in terms of, I'm saying he still is bringing the claim. He still has a forum for recovery, but the ultimate monetary outcome at the end of the case, just as in a civil action, is never guaranteed.
Is that the way that this was analyzed in the Injured Workers versus Franklin case?
I don't believe so.
Okay. If we're going to analyze it the way they did, which I think is there has to be an adequate substitute remedy, how would a zero recovery for the rotator cuff injury be an adequate recovery?
Well, they still analyzed it under reasonable, necessary, in the public interest. They did still analyze it under the 2-prong test for constitutionality. And in that case, again, with the stricter notice requirement, it could be the same situation. You could have an injured worker, horrific injury at work, but if he had failed to give timely notice, he would have received no recovery, including no medical care and no lost time or temporary total benefits, and finally no permanent partial impairment or permanent partial disability. So that very issue was a component of Injured Workers v. Franklin.
Get back to something a little more fundamental, at least for me. What's our standard of review in reviewing this legislation?
The standard of review is unlimited in this instance, Your Honor, since it's a constitutional issue.
And how do we treat the proceedings before the, it's unlimited in, as to whether as a matter of law, this is unconstitutional. But what do we do with the fact testimony presented before the committee, legislative committee?
You're not talking about the lower proceedings in this case, you're talking about the legislature.
No, I'm before the legislature.
I think the legislative intent obviously should bear on your thought process and your decision-making in this case.
Well, we're not bound by, are you saying we are not bound, we're not bound by the facts? Well, we have conflicting testimony before the legislative committee. How do we view that de novo? How do we handle that?
I think the fact that there was conflicting testimony adds to the argument that the legislature reviewed this and it wasn't made in a vacuum. There was a bargaining process between the parties. Interests on behalf of injured workers were present to state their case. Parties on behalf of labor and employers were there to state their case. All of that was taken into consideration. And so the legislature, taking all of that together, then arrived at this change going to the 6th edition.
I'd like to ask you about a couple of statements in the other party's brief to see if you agree with them.
All right.
You all are much more expert on the intricacies of the work compact than we are, so I want to just check on this. At page 29, they say, restoration of lost earning capacity is an essential element of the act. Would you agree with that?
I would agree with that.
Okay. And then later in the same paragraph, they say, only permanent partial disability compensation does that, making it indispensable to fulfilling the intent of the act.
I do not agree with that.
Okay, explain to me your disagreement with that
I
provision.
think the obligation under the Workers' Compensation Act is to provide medical care to the employee to restore them as best possible to their pre-injury function level, whatever that may be. Sometimes that's going to result in permanent partial disability at the end of the treatment. Sometimes it is not. There are cases where people have injuries, and at the conclusion of the injury or of the treatment, the physician says in his or her opinion there is no permanent partial impairment rendered by utilizing the guides. And that was the case even under the 4th edition. There are some injuries for which there simply is no permanent partial disability awarded. In Kansas, we don't pay people for permanent disability for a hernia, for instance. Contrast that to Missouri as an example. And I would like to point out, as is admitted in Mr. Johnson's brief, there were changes as a result of the amendments that actually benefited injured workers. After 2011, if an injured worker has a scheduled injury, such as a shoulder or a knee, and they are missing time from work but not 100% of the time, they are now entitled to what's called temporary partial disability. Previously, those folks were not entitled to that benefit. So that's an enhancement, a direct monetary enhancement that is as a result of the 2011. The monetary caps were also raised for permanent partial and for permanent total disability. And we also saw the change from bilateral extremities can now again statutorily be considered body as a whole, which can trigger potential for work disability, which is a heightened recovery.
Would you comment on the remedy if we were to find the statute unconstitutional, either generally or as applied to Mr. Johnson?
Well,
What should we do about that?
I would argue that if you find the application of the AMA Guide 6th edition to be unconstitutional, that we then revert back to the 4th.
What if we simply find that the combination of the pre-existing law plus that in combination is, I mean, the legislature could make this different with a different package. Those are two elements of a package. But your suggestion would be, in this case, the best solution would be to simply say, as to this claimant, apply the 4th edition.
Correct.
Okay.
The Act has been repeatedly changed, modified, amended over the years. And as has already been stated, the key focus of the Workers' Compensation Act is for a swift and efficient remedy for an injured worker and to guarantee predictability for employers so that they understand their risk and they can secure insurance appropriate to that risk level. To require litigation appeals every time there has been a change in the law, where admittedly every time there's a change, one or more parties is going to receive a potential reduction in benefits, one or more parties will see an enhancement in benefits, that simply would not be in judicial economy's best interest.
Well, looking over the litany of changes over the years, have there been instances when benefits have been enhanced as opposed to reduced?
Yes, Your Honor. That's what I was speaking about with the caps being increased after the 2011 changes if a person has permanent partial general bodily disability, what we call work disability. It changed from 100,000 to up to 130,000 that they could potentially recover permanent total.
But isn't that really the result of economic times and the change in people's pay?
Your Honor, I don't
I
know.
mean, if a person makes $1,000 a month and they get 2/3 or less than that during temporary total disability, it's not the same as recovering $1,000 a week.
That's true. Those benefits are still going to be tied into the person's average weekly wage. It's not a guarantee that they're always going to get the maximum, or it may be that they have to simply go a further number of years out to get the maximum. But those benefits were enhanced, and that was part of the legislative process to do that.
I think that pretty much takes up your time, counsel. Thank you very much.
Thank you.
Ms. Cook, you have your rebuttal time.
Thank you, Your Honor. Judge Lieben, you asked a question about a Court of Appeals case regarding the dismissal statute. There was one, I think it's Glaze versus Williams, where a case was dismissed with prejudice while a person was still receiving medical care and getting paid temporary total benefits.
And I think that case is still pending Supreme Court decision on a
The
petition.
Supreme Court is reviewing it, yes. Counsel mentioned the magnanimous, hard time.
Generous.
Yeah, that increase in the cap from 100,000 to 130,000 for work disability. Well, they did that, but the problem is you can't get work disability anymore. And this case is a prime example. In 2011, the legislature put a threshold, a functional impairment threshold of you have to exceed 7.5% impairment before you can get a work disability. In this particular case, Mr. Johnson had a good recovery to the point he got back to work. But given the severity of his injury, he's lucky. He could have been without the ability to go back to work. And had he not been able to go back to work, he still would have gotten $14,800 because his 6% did not meet the threshold for a work disability. And the other thing the legislature generously did is raise permanent total limits from 125 to 155. So if you're 30 years old, paralyzed from the neck down, can't work another day of your life, by God, you're going to get $155,000. Lucky you. So I'll leave you with this thought. What the legislature has done to injured workers in 2011 and then 2015 is akin to your employer coming up to you and saying, hey, I'm going to cut your wages by 75%, but I tell you what, I'm going to give you another half-hour lunch break. That's what they've done. And so we're asking the court to fix that. Thank you.
Thank you very much. Thank you for your argument. We'll take that matter under advisement and get an opinion to you as quickly as we can. Our next case is case number 118165, City of Leawood versus Robert Puccinelli.
May it please the court, Mitch Biebekauser, the appellant judge.
You were on the brief, right?
I was, Judge.
All right, very well.
Thank you, Judge. I'd like to reserve 5 minutes.
Why don't you wait just a moment
Sure.
for
Let's wait just a
people to
minute.
settle down. Understandably,
did
in
you
a
say 2
college
minutes?
audience, everybody
Gavel's
can't
here.
stay.
Did you say 2 minutes or 3 minutes?
I said 5.
Oh, 5 minutes, I'm sorry.
Whatever you're willing is fine, really.
No, it's your time to use.
May I proceed?
Take just a second, hold on. Counsel.
Thank you. Judge, I will use a minute or so of my time to review the facts for the sake of the audience. This case involves a driver who was stopped by a Leawood police officer for activating his turning blinker during but not before his turn. After the officer stopped the motorist, he came up on the side of the car, spoke with the motorist, and detected the odor of alcohol. He also noted the driver's bloodshot eyes. He asked the driver about drinking, and the driver, Mr. Pusinelli, denied any drinking. Their conversation went on, and eventually the police officer requested non-standardized field sobriety tests, the finger dexterity, the alphabet, and the counting test. Mr. Pusinelli responded that he's not going to get out of the car and take tests. And the officer says, well, I'm not asking you to get out of the car at this point. And so at the officer's direction, Mr. Pusinelli completed those tests I described, the finger dexterity test, the alphabet test, and the counting test. At that time, the officer changed his mind and says, I am going to have you step out of the car. And Mr. Pusinelli responded, he's not comfortable with that and doesn't want to get out of the car. And the officer essentially directs him, I'm not asking you, I'm telling you. He says, comfortable or not, you need to get out of the car. At the motion to suppress, the officer testified that really he didn't have a choice, that he was ordered out of the car and that's what needed to happen.
Who testified to that?
The officer did. He testified that he doesn't have a choice. If I ask him to get out of the car, he gets out of the car.
Right, but there's a difference, isn't there, between whether you get out of the car and whether you do the field sobriety test?
Yes, sir. I think so. Yeah, I think so.
One of the basic questions I've got here is, the trial judge, after hearing all the evidence, found that he took the test voluntarily.
I think that's right, Judge.
And I'm trying to figure out whether that's supported by the record, because
It's right that the judge found that, or that he cooperated voluntarily?
I think it's right that the judge found that.
Okay.
right. And so normally, if the judge's factual findings are supported by the evidence, we accept them and move on. And you're arguing there's a legal issue because he didn't voluntarily submit to the test. But if factually you're wrong on that, there really isn't an issue, is there?
I disagree, Judge. I think there's two steps to the analysis here, and I think that's set out by the standard of review. First is whether the finding was supported by substantial competent evidence, and second, whether or not that finding was supported by the law. And that, I think, the court reviews de novo. So, Judge, I would first...
but as to the facts, you didn't ask for any more specific fact findings. Let's take each moment along the way and decide what he did voluntarily, what he didn't do.
I think the judge did that sort of in a broad stroke.
Right.
Correct, Judge.
So make your argument for why, even though the trial court found that it was voluntary, we should overrule that and say it wasn't.
Judge, I think what I'm asking the court here to do, what Mr. Pusinelli is asking the court to do, is determine that the ultimate legal conclusion was not proper, and that is that Mr. Pusinelli did refuse, whether that's couched as it wasn't conducted voluntarily, or whether the court found that he didn't have a right to refuse. I think the court needs to determine
The court didn't
that.
say that. The trial court didn't say, I find he didn't have a right to refuse. It said he voluntarily did it, right?
I think the question's sort of mixed in that sense, Judge, because I think here we're suggesting that if Mr. Pusinelli had a right to refuse, he exercised that right, and that was denied by the officer.
Well, can we just go through the evidence a little bit
Sure,
then?
I'm happy to, Judge.
So I'm not comfortable was about getting out of the car, and that wasn't about testing, you'll agree, right?
I think that's fair.
Okay. So he then asked him to do the walk and turn test, and your client said, just give me the breathalyzer. He didn't want to do any tests, he just wants to move on to the breathalyzer.
Right. He didn't want to do the standardized field sobriety test. He wanted to move on to the PBT. That's what he asked.
And the officer said, we don't do it that way, we go through a step-by-step process. He didn't say, I refuse, he then did the walk and turn test.
Well, and I think that's the heart of the issue, Judge, and we can go through a number of these and go through the facts. I think he says,
Well,
I'd
it
rather
looks-
do the breathalyzer.
It looks to me like there's only like 3 times this comes up, they're all very similar, where he says, let's just go on to the breath test, and he says, we go through this step by step. Next, I need you to do this, and then he does this.
That's right, Judge, and I think the question for the court is, how many times does he have to say no in one form or another before the officer is required to honor that no and not conduct the test? I think that's
Right.
the question for the court.
Right, but what he's saying is not really, no, I don't want to do this test. What he's saying is, I'd like to move on to the later breath test, the one he ultimately denies doing when he gets down to the station,
Judge,
declines doing.
Judge, I think a number of times in one form or another, Mr. Pusinelli decides that he doesn't want to take the test that's being offered. Whether he says, I'd like to move on, whether he says no, whether he says, I'm not comfortable, whatever the specific verbiage is, I think in some form or another, he's trying to deny that opportunity. He's doing it politely.
Okay.
He's not physically resisting.
Sure. Let me move on to a different question. In your analysis, my understanding is you're likening this to a consent search.
Judge, I think I want to walk that back and try and clarify my argument some, and because I think that...
That's what you briefed.
Well, Judge, I think I'm likening it to a consent search. I think that's right. I'm likening it to that because I don't think there's a good bucket to put it in terms of Fourth Amendment analysis. I would agree, and the city responded to this, I would agree that this field sobriety test can be done based on reasonable suspicion. I think that's how we do it in Kansas. I think that's how the majority of states do it around the country. So I think reasonable suspicion is a test, and I think that likens it to a Terry stop. But I think at some point, Judge, it's likened to a consent search because somehow the motorist has to voluntarily enter into the testing process.
Well, my question was going to be, if it's treated under the standard for a consent search, it has to first be a Fourth Amendment search.
I think it is a Fourth Amendment search. Whether it's reasonable suspicion or whether we get to consent, I think it's a Fourth Amendment analysis.
And both parties agree, I think, in their briefs that we have conflicting case law in other states about whether field sobriety tests constitute a search under the Fourth Amendment.
That's right.
If it doesn't constitute a Fourth Amendment search, does that end the issue?
Well, I suppose...
In other words, do you still have any claim if it's not a Fourth Amendment search?
I think then, Judge, we'd still have the Kansas Constitution to the extent that it could be distinguished, and we maybe have some statutory ground. I think otherwise, I think it's a Fourth Amendment question, Judge.
Okay. What statute did you claim in your brief that's...
We didn't, Judge.
Okay.
No,
All right. So
Judge.
We're faced then, from your standpoint, with a Fourth Amendment call.
I think so.
Okay. Why would we not follow the decision of the Washington Supreme Court from 2016, I think it was? Are you familiar with the Mitchell versus State case? That's not the right one. That's Georgia. Anyway, Georgia and Washington both have come out in the last 2 years on the side that this isn't a Fourth Amendment search.
Were those cases brief, Judge? I'm going to have to...
I'm not sure they were. I'm not sure they were.
And I'm not sure that I'm familiar with them,
Just
so I can't
give me
respond.
your best pitch on why this is a Fourth Amendment search.
Thank you, Judge. I think this is a Fourth Amendment search because reasonable suspicion is required to conduct field sobriety testing. I think all the cases that I reviewed, and maybe the cases you've cited too don't, but I think all of them agree that at least reasonable suspicion is required. In some cases, I think some states have gone so far as to say probable cause may or may not be required, but I think reasonable suspicion is at least required, which puts us into the framework of a Terry stop, and that does require Fourth Amendment analysis. Now, when we're in a Terry stop scenario, the Fourth Amendment question still arises, which is this test reasonable? And that's sort of the touchstone of the analysis. Terry stops are authorized because they're reasonable, because it's a limited duration to gather evidence specific to some observation, and the detention is lesser. In this case, Judge, we're still faced with the Fourth Amendment because we have a detention, we've stopped the motorist on the side of the road, and we're conducting an investigation based on that reasonable suspicion.
Right, but you didn't argue in the trial court that the Terry stop was improper or that it was improperly extended.
I don't think it's a sort of a Rodriguez extension issue, Judge. I think the question is whether the Terry stop of the motorist was reasonable. Whether when we're going to ask him to do all of these things, if he continues to say no, if he says, I'd rather do a different test, I'd like to move on, I'm not comfortable with this, at what point do we say enough is enough, he said no, and let's move on? Because the next thing that happens, Judge, is...
But the standard of reasonable suspicion doesn't really have anything to do with consent. It's, do you have reasonable suspicion to believe this person was driving under the influence of alcohol?
But a reasonable search still does require some level of consent because the search has to be reasonable.
That's if it's a search.
And I think it is a search. Whether we're under the Terry analysis or not, it's still a search.
How is it a search?
Well, Judge, because here we're stopping the motorist and we're conducting an investigation. In the same way a Terry stop is a search, where we stop the person.
Well, Terry
we ask them
stop, you
questions.
actually you can pat somebody down for weapons.
Right, and here
We're not. You can conduct these tests without ever touching the person.
I don't
not invading their person, are we?
Well, I think we are, Judge. We're stopping them, we're detaining them, we're asking them to conduct certain tests. Whether we touch them, I don't think is the issue.
What is the purpose of these tests?
To gather evidence, to determine evidence of a crime.
It make observations about the extent that the person may be intoxicated?
Yes.
and they can do that simply by the test is just a formalized way of observation, isn't it? I mean, you could find a grounds to arrest someone for DUI because of the fact that they're unsteady on their feet. They have to hold on to the car. They're slurring their words. Their thought processes are so jumbled that they mix up words, which is what happens in some of these tests. Isn't that true?
I think that's all true, Judge. But I think in the examples that you're providing, those are done those observations are spontaneous. They're not a result of any command to do this or that, to balance or walk this way, or to look this direction or don't look that direction. I think when the questions, and it's still investigatory, I understand that, but when the questions or the demands are, do this or that, we're compelling that kind of testing. And the standard to be able to ask those questions, I agree, is reasonable suspicion. But whether the test is voluntary turns on the officer's use of force, either verbal use of force or physical use of force, to compel those observations.
So tell me if, I didn't mean to interrupt.
I was just going to say, it may not be voluntary to force a suspect to be viewed in a lineup, for example. There's no Fourth Amendment involved in forcing someone to stand in a lineup so they can be identified by their physical appearance.
Judge, that's not the issue today. I'm not.
Well, no, I understand, but the analogy is that we're talking about making observations about a person's condition.
I think that's
ritualizing that in the form of a non-invasive test. How is that different from having someone say, stand up in that line and we're going to have the victim see if they can identify you?
Well, Judge, I think that's different for a few reasons. One is typically those lineups, in some cases at least, those lineups are voluntary. They're asked to come in and stand in a lineup, so that would be voluntary. Assuming that is compelled, Judge, I don't think that's the officer's observations then. They're asking for a third party's observations. They come in and they're asked just to stand there. They're not asked to do one thing or another, and maybe they are. Maybe that issue needs to be litigated, and maybe that comes next. But here, Judge, I think
it has been litigated.
I think, Judge, what we have to do next is determine whether or not these issues, the things that he was asked to do, did raise to some investigation, some physical investigation. Some do this or do that. And I think the evidence is clear that at least happened.
All right, so here, back to my question. What was his obligation? Couldn't he have just stood silent and moot and refused to do the acts? And by the fact that he said he didn't want to do it, and then he did it, didn't he waive his challenge and consent by carrying through?
Judge, I don't think so. And I think the reason why he didn't is because I think the motorist then has to ask themselves, well, what comes next? If I say no and the officer tells me to do it anyway, what am I left to do? Because now maybe I just sit on the ground. And what does the officer do then? Maybe he orders him up. And maybe Mr. Pusinelli decides to keep sitting. So the officer grabs him and pulls him up.
There's no doubt that an officer has the right to have a person step out of the car.
I agree.
Right?
I agree.
And that the officer's in control of the situation because it's a stop.
I agree.
But it doesn't mean that the alleged driver or the defendant in this situation couldn't just say, here's my driver's license and my name is so-and-so, and that's it.
I think the question, though, becomes if that happens and the officer says that's not good enough for me, how far can the officer go? And I think that's the clarity that we're looking for with this decision, Judge.
So you're likening this to a person invoking their Miranda right and the officer ignoring it.
Well, I suppose that's likened to that. It's not analyzed under a Fifth Amendment analysis, but I agree.
But it's not. You haven't briefed it, but that's kind of what you're drawing a relationship to, aren't you?
Yes, and I think I likened it to a Fourth Amendment search, a consent search. But either way, I think the analysis is the same. How far can a police officer go? Do they get to draw their weapon? Do they get to point a gun to their head? Do they get to taser a person? Do they get to order them to the ground? At some point, I would submit, at some point, this court would find it too much. Maybe that's not this case. But at some point, the court's going to find that officer went too far to compel these tests. Whether they're based on reasonable suspicion or not, the officer did too much. And I think that's the kind of clarity that we're looking for from this court. If we're going to say, well, they're not consensual tests, if that's the decision, well, then what are they? Because that gives the police officer's license to order them up, to grab them, to hold them in the search position. How far can a police officer go? And we're looking for some clarity to draw that line.
Counsel, you've gone well over.
I'm going to screw that problem up a little bit because I got one more question.
Oh, no,
Please.
that's fine.
You've got a second issue in this case which deals with the horizontal gaze nystagmus test, which our Supreme Court has held as to result is inadmissible. The result arguably wasn't presented in this case, but the fact that that test was one of the ones used was presented in the jury trial. My question is, given the other evidence that was presented, is that a harmless error here?
No, Judge, I don't think so.
And why not?
Because I think the horizontal gaze nystagmus test presented at all, especially as the first test that's presented as evidence, and the idea or the insinuation that it's somehow a test or scientific evidence becomes so weighty that it's at least as valuable as the other tests, and it's up to the jury to decide how much weight they want to put on those. I think the remainder of the evidence is not so weighty that it overcomes the notion that this test was in some way standardized or scientific. I think, thanks for directing my attention to that question before I have to yield my time.
Sure, thank you.
If I have any time left, I should probably reserve it.
Well, you don't, but I'll give you a couple minutes for rebuttal and extend the time for,
She has as much time as she likes and the court will allow. Thank you.
yes.
Good morning. Marcy Knight on behalf of the Applee City of Leawood. May it please the court?
Counsel?
There were a lot of questions on the first issue in this case. Judge Lieben, I think you were right on when you said that Judge Sutherland found that these tests were voluntary, and I think that's the finding on this issue.
So is that supported by the record when he makes the comments, I'm not going to do it, just give me the breathalyzer? That's what he said when he was asked to do the heel-to-toe walking test.
The walk and turn is the only test.
The walk and turn's the first one, and he said there, just give me the breathalyzer, something to that effect. And then when he got the next test, he said, I'm not going to do it, just give me the breathalyzer.
Yes, that's during the walk and turn test.
Okay.
That's the only test during which he actually objected and said, I'm not going to do it. All of the others, as you mentioned before, were kind of non-responsive, such as I'm not going to get out of the car when the officer did not ask him to get out of the car. That was not an objection to a test. It was actually kind of non-responsive. The city included in the record on appeal the videos that were shown to the jury. Right. I don't know if this panel's had a chance to review them. I would encourage you to review them. They are what the judge considered at the motion to suppress level, and the jury was shown these videos. And I think you can review them under...
Video didn't include the HGN test, did it?
It included a portion of the HGN test.
The shining of the lights in the gentleman's eyes?
Well, that's not really what the HGN test is, but the...
Well, it's a following of the eyes.
Following the pen, yes.
Right.
A short portion of it was included in the videos.
I'm sorry, using the lights, because this happened at night,
Yes,
but it's shining, asking the person to follow a pin with their eyes.
yes.
And how the eyes react to the pin movement is what the officer's looking for.
That's what the officer's looking for. The jury was never instructed or told that's what the officer's looking for. You cannot see any of that on the video in terms of what actually nystagmus is, which is the involuntary jerking of the eye. You can't see that on the video. And the jury was not told about that.
But what purpose was it to give this test, to show this to the jury when the ultimate result wasn't allowed?
I'll tell you why. Two reasons. The first reason was Mr. Puccinelli's failure to follow simple instructions. That is an indicator of impairment. That's why they do the counting test and the alphabet test. You have to remember what they told you to do. For HGN, the officer instructs him to stand with his hands down at his side, follow a pen with your eyes and your eyes only, and don't turn your head. Well, Mr. Puccinelli, right after hearing that, he turns his head, and then he looks at the officer, and the reason I wanted to include it to the jury is for that reason. Mr. Puccinelli says, what do you want me to do? Look at the pen?
But aren't
Moments
you-
after the officer told him to look
But
at the
aren't you
pen.
telescoping to the jury that this test meant something, but you haven't told them?
No. What the jury hears is the officer asked him to follow the pen with his eyes and his eyes only, and he was unable to do that. Then there were, the
Our
second
Supreme
part,
Court has said that it's not admissible.
the results. And Judge Liebman referred to that earlier too. The results of the HGN, which are 3 specific things that an officer is looking for.
And don't generally most courts just exclude the whole test?
No.
They're allowed?
I've been prosecuting for 20 years, and State v. Witt was decided before I got out of law school. My entire career as a prosecutor, we have not been able to talk about the results of HGN. But in many cases, when an officer is administering HGN, the subject is swaying back and forth, or they turn their head and fail to follow the pen, or they make statements. And all of that should be admissible and was admitted in this case. To rule that kind of extraneous observations, not the results, but the other observations during the HGN, if you rule that those are not admissible, I think that's not allowing the state and the prosecutor a fair trial. That's evidence of intoxication.
But did the officer tell the jury at the end that he concluded there were grounds to arrest this guy because he had failed the tests?
I don't know that he said that specifically. He was asked at the end of all the tests, the last one being one-leg stand, what did you do next? I placed him under arrest for DUI. He is asked to explain what's the purpose of the test, including alphabet and counting and standing on one leg, and he explained there's many reasons. I'm looking for divided attention, ability to follow instructions, physical, motor skills, balance, all of these things are what he's looking for. And so that's why I wanted to show only a portion of the HGN. I didn't include the whole thing on the video for time's sake, and because once Mr. Puccinelli stopped talking and started following directions, there wasn't a whole lot of information there. But I do think it's fair to show the jury the statements he made during the HGN, which were, do you want to give me the breathalyzer? I'm not drunk. And what do you want me to do? Look at the pen? When the officer just told him to look at the pen. I think that's very compelling evidence of his inability to mentally process that information.
What are you saying are the results? What is the officer looking for as results of that test?
And that I did include in my brief, and that's what is in Molitor and it's in Witt. The 3 results, and there's 6 possible clues on the HGN, 3 for each eye, so 6 total. Angle of onset of nystagmus is on page 11 of my brief.
Okay.
Distinct nystagmus at maximum deviation and lack of smooth pursuit. None of those.
So none of the things that you're saying are the prohibited results relate to whether somebody followed instructions.
Right.
So while the officer looks on every test to see whether the person followed instructions, you're saying that there's nothing in Kansas Supreme Court case law, Molitor or otherwise, that says you cannot allow the fact that the person failed to follow the instructions on the HGN test into evidence.
Correct.
Okay.
In fact, I think you can and should, because the cases on HGN, the reason it's not admissible in Kansas is because it's scientific testimony. So you need to lay foundation as to what does nystagmus at maximum deviation mean. What a lay juror doesn't know what that means, but a lay juror certainly knows what it means when you say, follow the pen with your eyes, and you fail to do that.
Court in
But you just said they couldn't see that.
Right, the nystagmus.
They couldn't see the eyes following the pen on the video.
They could see that. What I said is they could not see the inadmissible results, which would be nystagmus or the involuntary jerking of the eye. You can't see that. You could plainly see Mr. Puccinelli's eyes track to the right or left and then dart back to the officer.
his eyes or his head?
Both. He moved his head a little bit, but his eyes
video's
come
so
back.
good. The video, I had my clerk watch it instead of me so far, but you're saying the video's so good you can see the eyeball?
Well, the body cam, there's a car camera and a body camera. And so the body camera is on the officer's chest. So it's a couple feet away from Mr. Puccinelli's face.
Fair enough.
But you cannot, because I was very careful. I did not want, if you could see nystagmus in his eyes, I didn't want to show that to the jury. because I didn't want to get in a trick bag where I'm asking for something, but you can't tell that there's any nystagmus. What you can see is he is not following the pen with his eyes because he looks back to the officer and then says, what did you want me to do?
Do we have any case that actually says what you're saying, which is that failure to follow instructions on that test is admissible?
Not really,
Okay.
no.
And then if we find that it was improper to have any of the evidence of the HDN test in the trial, why is that not sufficient to get a new trial here?
I hope you don't go that direction.
You've made that clear, but my
Okay.
question is, if we go that direction.
If you go that direction, I do think it would be considered harmless error.
And why?
Because the jury did not hear about the results. The jury did not hear the word nystagmus. The jury did not hear about the 6 clues. The jury only heard that he failed to follow simple instructions. The same evidence they heard when he failed to follow simple instructions in the alphabet and counting test.
So how did you argue his failure to comply with the nystagmus test?
Can you repeat that?
How did you argue to the jury the relevance of his failure to follow the instructions in the nystagmus test?
I didn't really argue relevance to the jury because I argued that to the judge at the time they tried to exclude it, that it was relevant, and the judge agreed. So at the time we had closing arguments for the jury. I don't remember that I focused on HGN because I'm very cautious of it. I'm aware of the issues it raises. So I didn't focus on that, but if anything, it would have been, I have to prove Mr. Puccinelli was under the influence to a degree where he could not safely operate a vehicle. We saw and heard evidence that he failed to follow simple instructions, he didn't have his mental faculties, that sort of thing. So it wasn't specific. Obviously, we didn't pull the jury on what they relied on, but the HGN, this part of the HGN is one small piece of this case. There was ample evidence in this case that Mr. Puccinelli was intoxicated.
Was there any threshold testimony by the officer in describing the test overall as to what kind of results he would need in order to justify arresting the person for DUI? In other words, I typically give 5 tests, and if the driver flunks 3 of them, then I'm going to arrest him, or if he,
No.
anything like that.
No. He only testified as to what he looks for in general with regard to all tests. And Judge Lieben, to address your point on harmless error, I think the other answer to that would be there was substantial competent evidence outside the HGN, as I explained to Judge Schroeder.
All right, so
Find him
tell
guilty.
me, back to the question of consent to do the field sobriety test. What would have been the options available to the officer had Mr. Puccinelli decided to stand there and look at him?
It happens all the time. And, you know, as I said, I've been prosecuting a long time. Mr. Biebighauser and I have another case where that is the facts. The gentleman did not do anything. And officers in that case have to make a decision based on what evidence they have. They try to get evidence, but if they have no evidence and somebody just says no, they have to make a decision on whether to arrest based on what they have. And that's not really the issue in this case, but that's what would happen.
Right.
People refuse field sobriety tests all the time.
Okay. I understand that, but some of our audience may not.
I wouldn't recommend it, but it does happen.
Well, it's kind of like your right to remain silent, isn't it?
It's not, because, and here's the trick, where a driver, you know, a driver doesn't always know what the officer has. Do they have nothing? Do they have reasonable suspicion? Do they have probable cause, right? In a case like this, an officer, in this case and generally, have reasonable suspicion of DUI. When you've pulled somebody over, they smell alcohol, they've admitted to drinking or not, or you usually have reasonable suspicion sufficient to justify a continued detention, sufficient to justify field tests. So that's what I think it could be likened to, would be a Terry stop, which would be a seizure. So then you can ask them to do these tests during your constitutional detention. So a driver may not know whether or not they have enough to arrest. So by refusing, You know, it makes me think of that U.S. Supreme Court case, Heibel, Arizona v. Heibel, Hiibel, where the gentleman was questioned by officers. He was in a fight with his girlfriend on the side of the road. Officers wanted his name, and he refused to provide his name. And the officer was very patient and pressed for a long time to try to get this gentleman's name, and he wouldn't give it to him. He ended up getting arrested for interference with law enforcement for failure to disclose his name. Mr. Heibel didn't know. Did the officer have nothing? You know, was it a voluntary encounter? Did he have reasonable suspicion, or did he have probable cause? That's the dilemma the public is in. They don't always know what it amounts to in an officer's mind. In that case, that went to the U.S. Supreme Court, and they said they had probable cause to arrest him because under the statute, he was investigating a crime, and Mr. Heibel had a duty to identify himself. So similarly, under the law on a DUI investigation.
That's a duty to disclose your name. That's different than the duty to perform.
It is different, just like Miranda. You likened it to Miranda and right to remain silent. That's a little different too, but I'm saying somebody doesn't always know whether the officer has a right to ask them to do these additional things. And I think an officer would have a right. And if a person would refuse a field sobriety test, I think that refusal of the test should also be admissible in evidence. It's not quite the facts we have here, but if it is a constitutional issue and it's supported by reasonable suspicion, I think that evidence would come into evidence, the refusal.
Yeah, I'm done.
Thank you, counsel. That's, your time is up.
Thank you.
Mr. Bobbighauser, do you have anything you want to add for a couple of minutes?
I'll do my very best to honor a promise to be brief. That's rare, maybe. I want to just address
Don't worry, I'll keep you to it.
Good, thank you, Judge. I want to address just two questions raised by the panel for Ms. Knight. The first is, what happens if the driver just stands there? Judge Schroeder's question. I think Ms. Knight's answer to that is not completely full, and that is, the police officer could decide to arrest, but the police officer could do a number of other things and compel testing in some other way. So the officer makes a decision, but that decision might not be arrest. It might be tackle to the ground. It might be display service weapon. It might be make some other kind of threat. And I think that's the danger. And so that's what we're looking for from this court, is to make some decision about how far can an officer go, and if no is not enough, what's the next step that can be done. And I want to just come back to the HGN before I sit down and say that maybe I would be more persuaded by the city's argument here if their position was the only evidence was of observations. If that's all this was, and she said, what else did you notice during the course of your stop? Well, he looked left and right a lot, and that seemed suspicious to me. That may be different. Here, the evidence was elicited in such a way that the officer was asked, what tests did you perform? And he described the 3 tests that he performed. Are those the routine tests that you performed? Yes, they're the routine tests. And did he follow your instructions? And if following instructions isn't a form of a test, I don't know what else is. And I feel like that's a clever way to maneuver around the evidence.
Our Supreme Court in Molitor didn't talk about following instructions being not proven to be relevant by science. They were talking about the more formalized things that happen to the eye during that test, right?
Yes, Judge, I think that's what the opinion was focused on.
Right, and normally, no matter what you would ask the person to do, if the driver can't follow relatively simple instructions, that would be relevant evidence on whether you're drunk.
In some cases, yes, Judge, that may be true. In this case, when it's...
In what case would it be untrue?
In this case, Judge.
That not following a simple direction would be relevant evidence on whether somebody's drunk?
I think in this case, when the following instructions is part and parcel and couched in terms of this is a test that we perform, when that language is used, it impermissibly conveys to the jury that it has more weight than it ought to, that test means something more.
You're saying the evidence is still admissible of the fact they didn't follow the instructions. What your actual objection to is the use of the word test.
I think when the evidence is used, whether observations or not, to convey to the jury that this is some standardized procedure, that I asked every driver to do these things, which was testimony evidence, that conveys to the jury that these observations are more weighty than other observations. And I think that's what makes it impermissible. And that's how the evidence came in, not mere observations.
All right.
I yield my time. Thank you.
Thank you. Thank you, counsel. We'll take that under advisement, get an opinion as soon as we can. take up our last case for this morning. Our last case for this morning is State of Kansas versus Jeremy Philbert, case number 117326. Appearances, please.
May it please the court, Corey Call, representing Jeremy Philbert. I would request 3 minutes for rebuttal.
Very well.
May it please the court, counsel.
Why don't you just wait just a second
Sure.
till we everything quiets down a little bit. You said 3 minutes?
3 minutes, please. Thank you, Your Honor.
All right, you may proceed.
The state alleged that Jeremy conducted inappropriate conduct with his sister. She was 9 to 11 at the time, and Jeremy was in his 20s. Eventually, he was convicted of 2 counts of rape, 3 counts of aggravated crime sodomy, and 1 count of aggravated indecent liberties. We raised 2 issues in the brief. One was the failure to give a sympathy instruction, and the second was insufficient evidence on the means chosen by the state of the aggravated criminal sodomy. Before we get started, if the court would allow, as I filed a couple motions before this, I had received correspondence from Mr. Philbert that he intended to have me removed as counsel and that he wanted to file supplemental briefing. The court denied those first on present showing, and I'm not sure if the reason the court denied it was because they hadn't actually received the motions from Mr. Philbert. He had sent them to the clerk's office, but they were returned to him for failure to serve.
I have no indication that they've yet filed.
That's right. Yesterday I received a second copy at my office. I called the clerk's office at 4:30, and they did not have any record of them then. But I did want to let court know that if you were waiting on them, I received them, and Mr. Philbert wants this court to consider all the issues, and so I would ask, I don't know what steps you can take to, obviously you can't delay forever or whatnot, but just to let you know that and I would ask for your consideration of other possible issues that may be coming.
Well, that's not unknown to happen.
Yeah, I understand.
Other issues to pop up, but the point is you're here. We're ready to hear your argument.
That's right. I just wanted to let the court know that it may be coming because I got it yesterday.
I understand.
So anyway, so as I said, the 2 issues were the sympathy instruction and the insufficiency evidence. I think the first issue was pretty thoroughly briefed, and I'm not sure. I certainly answer any questions the court have.
Well, my question is I can't tell from the record how long you're complaining about both the victim and the defendant crying on the witness stand. But how long did that actually take place? I mean, was it a minute? Was it 10 minutes? Because the court did not take a recess.
No, that's right. The court did not take the recess. It was enough that the court noticed it. It was mentioned it in both times, and they didn't take a recess, but I believe in both cases they certainly asked the witnesses, would you like a break? And maybe took sometimes you don't recess, but you take a short moment. It was certainly a noticeable to the jury that it was a very emotional situation for both parties.
And just correct me if I'm wrong about this, but as I understand, the victim testifies, is called by a witness for the state, testifies about what happened to her. In the process of that testimony, she gets tearful. She stops her testimony, and there's some sort of interval before she's able to compose herself and go on. Later on, your client testifies on his own behalf, and during his testimony, he becomes tearful, starts to break down, and there's a short break while he composes himself, and they go on. You wanted the court to give an instruction to disregard any sympathy.
That's correct.
And the court didn't grant that.
Correct.
Now, why doesn't that, if that instruction had been given, why wouldn't it cut both ways? How would it favor your client over the victim? I mean, a jury could easily say, gee, that poor young man's being dragged into court and is all broke up about it. I feel very sympathetic towards him.
Sure. Well, I think, and I think this is the right analysis, I think you have to look at the circumstances at which the jury would have, which sympathy would have played a role in their verdict. And with the victim, the way it would have played out is that they would think, gosh, I don't really believe her testimony. I'm concerned about this. Maybe something happened. She's obviously very upset. We need to find something here and do that, which I think that seems at least plausible to me.
They didn't find something, they found...
Absolutely. We don't know why, but yeah, because the instruction wasn't given.
things.
Sure, absolutely, absolutely. The flip side of that would be that the jury would believe, well, the state has proven this, that he had done these things, but he was very upset about that, and we don't really want to impose this burden on him, which that seems unlikely to me, that the jury would take that. It seems that the sympathy factor, to me, is much more prejudicial, is much more likely to flow towards the alleged victim than it is the defendant. That's how I see it, is the harm.
That the jury would be more sympathetic to her.
The jury would, yes, to her outburst than his outburst,
Now,
as far as the verdict goes.
district courts it's recommended that they follow the PIC instructions.
That's correct?
And that's a set of guidelines on how the jury should be instructed in each individual case. So our current PIC instructions recommends that no sympathy instruction be given.
I'm not sure that's correct, or at least let me say this, is that it's disfavored. Certainly, it's disfavored.
Right. No is too strong.
That's right. Well, it's important because I think the district court in this case, the way I read it, he said exactly that. We shouldn't do it. And I think that's incorrect. It's unusual circumstances in that. You hate to nitpick the Supreme Court, or maybe you do like to nitpick the Supreme Court, but I think they've been very good in the last 10 years of being very precise with their languages. And I think in Williams is the case the district court relied on. And I think they got a little loose, and I like a clean opinion. Instructions have to be legally appropriate and factually appropriate. And what the Supreme Court said in Williams was that the sympathy instruction is only legally appropriate in unusual circumstances. And I don't think that's correct. I think it's only factually appropriate in certain situations. It's legally appropriate. There's nothing legally barring this. And I think the state even concedes, it's a legally appropriate instruction. But the different facts may make it factually appropriate or inappropriate. I think that's the correct analysis. But yeah, that was...
But crying in the courtroom by a witness on the stand is not necessarily unusual. It happens all the time.
That's right. I think that the difference here, I think the crying of the defendant, I think, is an unusual circumstances. And when you have both sides, it creates a more emotionally charged environment than a normal case. I'm not used to seeing that. Anyway, that is the unusual element that I would say in this case.
I want to ask about your second issue.
Yeah.
And it seems to me that what you've tried to do is pull a rabbit out of a hat by changing the issue from whether the instructions were clearly erroneous to insufficiency of evidence. The charging document in this case charged a violation of subsection B1.
Correct.
Which is...
Engaging in sodomy.
Sodomy with a child under the age of 14.
Yeah, engaging in sodomy.
Well,
Yes.
it's
Right.
sodomy with a child who is under age 14 is what the statute says.
Right.
Okay.
And then you're claiming that what they instructed was a charge under B2, which is causing a child under age 14 to engage in sodomy with any person or an animal.
That's correct. That's what I'm claiming.
But in the jury instructions, they were very clear about what they were engaging. They did use the language, the defendant caused JF to engage in sodomy with a person, but we had two different counts, and the complaint in count 3 alleged oral copulation with a child under the age of 14, to wit, JF, the victim in this case. And then in instruction number 9, where they had that language in item number 1, at the end, they have an instruction for the purposes of this count, sodomy means oral contact of the male genitalia. So with a female victim under the age of 14 and a male defendant, we know that what's being instructed in instruction number 9 is that the charge is that the defendant had the minor have oral contact with his genitals. That's clearly what's charged and told to the jury.
I would agree that's clearly what's charged, but that, to me, that is clearly what is not instructed the jury, because the instruction number we're on volume 1, page 75 of instruction 9, says the defendant caused JF to engage in sodomy with a person, which is that mirrors the language of 2, which is a different prohibited conduct.
Is the defendant a person?
He is a person, but that's
In this trial, was there any other person that any evidence suggested JF had had any sexual relation with?
no. There was a
So how would the jury not understand that what we're talking about here is JF, as the charge was, having oral copulation with the defendant?
Well, I think they probably would have understood that, and that's not what my issue is. My issue is that this instruction doesn't refer to that section of the statute. The instruction has to tie to an actual crime in the statute.
Well, the instruction doesn't cite anything in the statute.
No, but it mirrors the language from the subsection 2, which is I think of as a pimpin' statute. It's causing a person to do it. The legislature created 2 different ways to commit sodomy. One is you engage in it yourself, or you cause another person to do it. They separated them out in 2 different sections. If you look at the third one, there's a third section there that talks about, if I can get it here, sodomy with victim who does not consent, or causing the victim without the visit to consent. So there, in that subsection,
certain circumstances, when
in certain circumstances, right.
The victim is overcome by force or fear, or the victim is unconscious or physically powerless, or incapable of giving consent because of some mental deficiency.
Right. So the legislature shows there that they clearly consider there's 2 different types of sodomy here: engaging in sodomy and causing a person to engage in sodomy.
Right,
those are 2 different things.
Let's talk about then.
You're saying causing to engage with a third person.
That's what I believe this means. Otherwise, they wouldn't need the first one.
And that's what you're saying. He was charged with doing it himself, but then you're saying the instruction to the jury led the jury to believe that he had a third person.
That's what they, not maybe led them to believe, but that's what they said they had to prove, and the state didn't present any evidence of that.
They were told to make that finding.
Exactly.
That a third person was involved.
Correct.
You're saying in the instructions, the state amended the complaint to a different charge that wasn't applicable.
Yeah, I'm not sure I would say it exactly that way, but I'm certainly saying that
Well, if they left the charge the same, all the evidence is he committed the offense they charged.
Right, but the jury still has to find the correct element, and the element that there was no evidence of the element that they were instructed on.
Okay, I got to make this very clear.
Yeah.
You are or are not claiming that the jury instruction changed the specific charge?
I didn't brief that issue. I think that's
Here's the reason it's important. You're making a hyper-technical statutory interpretation argument. You're saying that subsection B1 and subsection B2 are completely non-overlapping things.
Correct.
And if the state didn't change the charge and the charge is still actually B1, then the question is not whether the state has charged something different in the way they phrased element 1. The question is, does the instruction overall give a sufficient description of a B1 offense that the evidence can still be found by the jury to support it, which seems to me the answer is yes, because we defined at the bottom exactly what we were talking about, which was the exact charge that was in count 3 of the complaint.
Right.
Do you understand what I'm saying?
I'm not sure I do. Let me see if I can explain my thinking. We could maybe meet there. My thinking was I looked at this as alternative means under the right alternative means statute, where the court has said that if there are alternative means and the state submits a means that there's no evidence to prove that there's a super sufficiency problem and there's a sufficiency evidence problem. And so I'm not.
But that's not the claim you've made here.
I hope that's exactly the claim I've made here, is that there are different alternative means. The statute creates alternative means of committing sodomy. And that's the heading. I talk about Stacey Brown, which sets out the different alternative means, the test for determining alternative means.
But they didn't charge alternative means. They charged B1 only.
That's right, but I
They
don't.
elected B1 only. The only thing they argued to the jury is B1. And you're claiming that somehow, because the way they phrased the item number 1 in the instruction, that changed the charge as instructed to B2.
Well, yeah, but I don't think the state gets a pass on the alternative means issue because they didn't submit the viable claim. I mean, if they had submitted B1 and B2,
Well, see,
then I would win, right?
Okay.
Because under the alternative means, because there's no evidence to support the alternative means. Because I don't think because they didn't submit a viable claim that that alternative means issue goes away.
Talk to me about instruction 12, which is the other count that is
Yep.
an aggravated criminal sodomy count.
Correct.
In count 6, they alleged that he committed anal copulation with her.
Yes.
And in instruction number 12, they have the phrase at the start, the defendant caused JF to engage in sodomy with a person, but they define that at the bottom, that sodomy means anal penetration, however slight, of a female by any body part or object.
Correct.
So as defined in the whole, they're not describing her engaging with him, they are describing him engaging with her.
I would say in this instruction what they're describing, because it says defendant caused JF to engage in sodomy with a person. And as we talked about, I'm saying that under the subsection, that means a third person. So they can define sodomy
But see,
however they
see,
want.
Your third person relies upon this statutory interpretation argument saying that B1 and B2 have to be non-intersecting things.
Yes.
But they only charged B1. B2, the statutory interpretation is not what we're dealing with here. We're dealing with a jury instruction that defines what the charge is under B1. And it may be an inartfully drawn instruction, but I would contend that when you add the definitions they provide at the bottom on each of those instructions, it's very clear that they're still alleging what is a crime under subsection B1.
Well, I think, with all due respect, I think you're being generous when you say, I mean, when they the language they inartfully use exactly mirrors another subsection of the statute, then I think they're talking about another section of the statute. They're not defining that. And as far as sodomy goes, the question isn't about which sodomy was committed or how the sodomy was or anything about the sodomy. It is who committed the sodomy. That's what I'm saying. There's insufficient evidence of who committed the sodomy. So that they can define sodomy.
All the evidence is that he committed it.
That's correct. But I say that they instructed the jury that they had to find that somebody else did it, which there's no evidence to support that.
Would you agree that no one at the trial seemed to believe that the jury had been instructed that someone else had to have committed the act?
Absolutely. I'd agree with that. And I do want to point out that
Doesn't the fact that everybody understood what this instruction was supposed to mean have any relevance?
no, I don't think it does, because it's a sufficiency problem. And I think the jury sort of points out that the jury thought that too. And I absolutely agree. The jury believed that he committed these acts. The problem is the state has to.
So did the defense.
Yeah.
The defense attorney thought that's what was instructed.
That's right. But the state, if they're going to put a man in jail for life, they got to dot their I's and cross their T's on what crime he actually committed.
Now, were these instructions submitted by the state or instructions submitted by the defendant?
The way I looked at it, the state submitted instructions. I didn't see any instructions that were submitted by the defense.
I didn't recall any.
And the state, in their brief, they talk about invited error and Schreiner, but even there they said that the defendant failed to object, that's sort of the problem, which I'm not aware of any cases that talk about invited error when you fail to object to instruction. That you ask the court, and we can talk about that. So that's on Schreiner. So I think that, unless the court has any questions.
We have extended your time, but I'll give you a couple minutes for rebuttal. Let's hear what the state has to say.
Thank you.
May it please the court, the state of Kansas appears by and through Assistant District Attorney Wyandotte County Daniel Obermeyer. Your Honors, I filed my entry of appearance yesterday. I trust that you
Yes, we
received
saw
that.
that.
Thank you.
Thank you.
Your Honors, I think I need to begin by giving some of the very sordid facts of this case because it helps us understand how we came to this language in the jury instructions, cause JF to engage in sodomy with a person. The evidence in this,
It wasn't an error?
I don't believe it was an error, Your Honor.
Doesn't it match the pattern instruction for Kansas or the PIC for subsection B2?
That argument could be made. I looked at the PIC. I do not recall if there was any comment saying use this bracket for B2 only, use this bracket for B1 only.
Okay.
But it does mirror the statute. I will concede that. However, I think ultimately this is a semantics issue, the difference between active voice and passive voice. The relationship between JF and the defendant is that of half siblings. Jeremy Philbert is significantly older than JF at the time, as counsel noted. The first instance, JF was 9 years old, and Jeremy Philbert was in his 20s. And that what happened in 2012, that brought about the aggravated indecent liberties case, where he brought her to a gas station, the evidence was, bought her some things, and then touched her vaginal area. After that, we fast forward to 2015, where we learn of multiple violations against JF caused by the defendant. And by JF's testimony, it was the defendant's actions in controlling her, in manipulating her, in withholding books from her, telling her siblings to treat her differently, that he created a situation where she felt compelled to comply with his sexual demands on her.
But the jury wasn't instructed under the third option of the statute about consent, was it?
No, Your Honor. I'm sorry. I don't mean that to be my argument. I'm not really arguing supersufficiency here. I'm just trying to illustrate how this instruction could have been worded that way. So
Well, aren't we supposed to be, for lack of a better word, wordsmiths and be very careful with the words that are chosen and how a jury is to be instructed?
Yes, Your Honor.
And do you agree or disagree that the reference to a person could be the fact that he had a third person involved, and that the jury could perceive that there was a third person involved in the activities?
Not under these facts, no, Your Honor. And I would submit to the court that if it was referring to a third person, then it would say another person, not a person.
That's not what the statute says, does it?
The statute does not say that. But then again, under B1, I believe the statute doesn't say, it just says engaged in sodomy with the victim. I believe that that's what it's
Sodomy with a child who is under 14 years of age.
correct. Yes, Your Honor.
And then the second statute says, causing a child under 14 years of age to engage in sodomy with any person or an animal. And then it proceeds to 3.
Yes, Your Honor, I can see that's clearly what the statute says. But this instruction is still factually appropriate if we accept the fact, as Judge Lieben pointed out, that the defendant is a person and that his actions brought about these charges of sodomy. But for his actions, JF would not have been subjected to this. And I think that that's appropriate. It's very significant that the judge thought this instruction was okay, the state thought this instruction was okay, and dispositively, the defense counsel at trial thought it was okay. Defense counsel's entire argument was that Jeremy Philbert did not, would not, and could not do this. Those were the arguments that were presented. So what we're really dealing with here is an instructional error issue. And if that's the case, then we have to look at, would the jury have reached a different verdict had they been instructed defendant engaged in sodomy with JF? And the evidence is overwhelmingly no. It's overwhelmingly no. In this case, it was whether or not, the issue is whether or not the jury believed JF's testimony and whether the corroborating evidence from a coworker who had never met JF, who didn't even know the Philbert family, her contact with the defendant on one of his first days of work where he's making comments to her that his sister is looking at him in a sexual light, that he calls his sister a cum dumpster. She's good for nothing but laying on her back. This so distresses her that she feels compelled to call DCF. This evidence is overwhelming that Jeremy Philbert did the acts which the state alleges. So if we correct an error, a different result would not be reached. And as I want to emphasize, this is the difference between the active and the passive voice here. I think that maybe if we had a jury of English professors, they would be able to discern a difference between causing JF to engage in sodomy and engaging in sodomy. But as the evidence was presented, as it was argued, it's without question that the jury knew that the person referred to in instruction number 7 was the defendant. To go back to the sympathy instruction, at the time this...
Before you move on to that, you do recognize that there are different ways in which you can commit aggravated criminal sodomy.
Yes, Your Honor.
The statute sets out different ways.
Yes, Your Honor.
One is sodomy with a child. That's when the actor is the defendant committing sodomy. Or the second section, the actor, the defendant, causing a child to engage in sodomy with any person. Now, the defense argues that any person can only mean a third person, because causing a child under the age of 14 to commit sodomy with the defendant would render the first section totally superfluous. And we assume that the legislature doesn't adopt superfluous legislation. What's your response to that?
I agree with that completely, Your Honor. My argument is that this as instructed, was factually appropriate. It's just the jury was properly instructed on the law. I think that it's, under the facts of this case, it's more or less a semantic difference, because there's no argument that JF is engaging in sodomy with any person other than the defendant. So functionally, I don't know the difference between engaging in sodomy or causing JF to engage in sodomy with the defendant and engaging in sodomy with the defendant. I don't know of any practical distinction that you can make there.
Then
But
why did the legislature define two different specific points?
as Judge McEnany pointed out, because there's different ways you can commit this crime. But I think that this instruction, as it's written, as it was given to a jury, was appropriate for the charge under B1, that he engaged in sodomy. His actions caused her to engage in sodomy with him. I mean, the practical difference there is, well, I can't really see a practical difference. Unless the court has any more questions on issue 2, I'll just go back to the sympathy instruction. The district court did properly consider the factual circumstances in addressing whether or not it was appropriate to give a sympathy instruction. It specifically cited the State v. Williams case and noted the factual circumstances of that case, where the defendant was crying at different points throughout the trial. And here the court noted that we had, if we go to volume 9, page 533, quote, "But here we had crying episodes," and I don't mean that bad when I say episodes. Crying situations with both the victim and the defendant. He says specifically, I don't mean that bad. So in terms of, from what Judge Griffin saw, from the demeanor of the defendant and of JF, it didn't rise to that level that we see in Williams, where it's an unusual circumstance justifying a sympathy instruction.
And do you know I know you didn't try the case, so do you have any, in talking to the prosecutor that tried the case, do you have any idea how long the crying episodes by each individual took?
I do not, Your Honor. I didn't ask that information because I thought if it wasn't borne out in the record, I didn't know if I could present it to this court. So I would think that, but I would defer to Judge Griffin here, saying that this doesn't even rise to the level that we have in Williams. So applying that case, he saw it as factually not appropriate. And the one case that the state could find that does support the giving of a sympathy instruction is State v. Roan. And that's
State versus what?
versus Roan, Your Honor, R-H-O-N-E.
Okay.
That's in the state's brief with the site and everything. But in that instruction, one of the witnesses was paraplegic. They could not move out of bed, so the jury had to hear their testimony from this person's sick bed. Obviously a case of extreme sympathy, very unusual circumstances. We're taking the jury outside the courtroom to see this very sympathetic. So in that case, it was appropriate. I couldn't find, I don't think the state could find, this counsel could find any other cases that would support the giving of instruction, of that instruction under these circumstances. And I note that it was removed from the pick forth, potentially for that reason. It's an unusual instruction because it instructs the jury not to do something rather than what they should do. I would also note that in volume 9 on page 557, the state explicitly says we're not to use emotion or sympathy in our deliberations. So in a sense, she did tell the jury that they're only supposed to consider this case according to the law and the facts, which is what they were also instructed on. So if there's any error at all there, I think that what we do is we assume that the jury followed the instructions it was given and did not decide this case according to its emotions. Then that's also shored up by the weight and credit instruction. That's an issue for the jury. Unless the court has any other questions, I'll yield.
Thank you very much. Thank you for your argument. Mr. Call, you can take a couple minutes if you need it to wrap up.
As far as the state's argument that it wasn't a mistake to give the instruction, the sodomy instruction, on their brief on page 18, they say the state concedes that it should have been worded as the defendant engaged in sodomy with JF and can provide no explanation as to why this mistake was made. So at least then it seemed like the state thought it was a mistake. As for on the sympathy instructions, the district court's comments that I don't mean that bad, and it's cold record, it's tough to read. What I took that to mean as, he said there was crying episodes, is that I don't mean that bad. He was saying, I'm not saying it was wrong that people were crying. It's not bad that they were crying. That's how I took it. I didn't take it to mean that he was saying they weren't that bad. The crying episodes weren't that bad. He was saying it wasn't a bad thing that the witnesses were crying. That's how I took those comments. And I would also point out that in the Williams court, I believe, if I remember the case correctly, that was the Supreme Court affirming the giving of the sympathy instruction. Now, in that case, they did a lot on the deference of the district court, found that it was appropriate. We're going to defer to that. But here, I would think that the way I read the record, the judge didn't make any findings about whether this was an unusual case because he said, Williams says we don't give this. So he didn't make the factual findings necessary. That's how, again, the record's there. This court can read it, but those are my comments.
Thank you very much. Thank you for your argument. We'll take that matter under advisement. That concludes our morning docket. We will be back here at 1:30 to hear some additional cases. In the meantime, if any of you that are here have any questions of us, we'd be happy to entertain those questions, so long as, and counsel, you're welcome to stay or
Ask questions?
Yeah, about anything other than the cases that we heard this morning. We'll be happy to try to answer them if anyone has a question. Yes, ma'am.
If you, of course not today, but if you hear a case where the attorneys are missing something or they don't argue something that they should, do you have any discretion to guide that?
Well, that goes to a very interesting fundamental issue about how active we should be in considering a case. We're ultimately trying to find come up with a just result that's consistent with the law and the facts that are before us. On the other hand, we are not advocates for one party or the other. We're not here to advance one side's position. Some people take a very hard line and say, if they haven't raised that, we're not going to consider it, even though it may be dispositive of the whole thing. Others are more lenient about that. I'll defer to my my brethren here to see what they have to say about that.
Yeah, I've got one, and this is something that divides judges. Actually, some of the hardiest arguments I've seen between judges on my court is on this question. But I'll give you an example where I think we can and should at least tweak an argument the parties make. Oftentimes, because most of law now is based on statutes, the interpretation of statutes is a key to our decision. And sometimes the parties will cite the right statute, but not interpret it in the way we may think it should be interpreted. And since the statute is involved, and the meaning of a statute in the state of Kansas shouldn't depend on whether Mr. Call or Mr. Obermeyer made the right argument in the case of Smith versus Jones, it ought to rely upon what does the statute in the state of Kansas mean. I feel free to interpret the statute based on my understanding of it, looking at other similar statutes that may draw meaning to it, the whole act that was passed by the legislature, things like that. So that's an area where I think we can and should supplement what the attorneys do, but the overall question's a tough one.
Yeah, it's not, I generally view it as, I mean, I have no problem with statutory interpretation, but if it's a legal argument that could have or should have been made and was not, it's not our job to raise that. That's the lawyer's job, and there may be reasons that they did not raise it that we don't know about. So if they dropped the ball, if that's for lack of a better term, we're not going to pick it up and include it.
Other questions? Yes, sir.
You got to explain in the student kind of process from here on out.
Yeah, what we will do is later today, we will meet, the three of us, and have what we call a conference, excuse me, in which we'll come to a basic decision on how we think the case ought to come out based upon the briefs of the parties and the arguments we've heard today and the discussions that we have. Then one of us who is already pre-assigned to write the opinion in the case, assuming that that's the majority opinion or the unanimous opinion of the panel, we'll start writing it up and eventually circulate it to the other two, and depending on on the issues, maybe even to the whole court, all 14 members of the court. But we go through that process before we issue the final opinion. If, of course, the one who's originally assigned to write the case is in the minority, then one of the other judges will write the majority opinion for the other two, and the one who originally was supposed to be writing that opinion will be writing a dissent of some sort. That's fairly rare, quite rare, as a matter of fact. And oftentimes, after we've taken this preliminary vote on how we think the case ought to turn out, the one who's doing the writing may come back to the other members of the panel and say, you know, this thing just won't write, which means in further reflection, when you start trying to put it together and get it on paper, and so that it logically follows, it just does, there's something we overlooked or something we overlooked in our analysis that changes that we missed. And then we go back and we may reconference it, talk it over again, and decide what we're going to do. And then once all that process is done, we issue a written opinion. We try to issue our opinions within 60 days of the oral argument. Our track record is we usually get those opinions out in about 45 days. So it's important to us that we don't leave the lawyers and their clients hanging, twisting in the wind, wondering what's going to happen. We do our best to try to get an opinion out as quickly as possible. Yes, yes, sir.
I have a question about the paper summary with the Philbert case.
Yes.
Why does the victim's age say less than 14? Shouldn't it be 16?
Well, and I don't have that description in front of me, but the crime, the element of the crime is that she was less than 14 at the time the crime was committed. So we've summarized the facts as they related to the legal issues that were before us, not necessarily to what somebody's age is today. Was that the question you had? Did that answer your question? Okay.
Just gentleman in the
Oh, in the back, yes, sir.
Does her age being under 14 make it an off-grid in the state of Kansas?
I think our right. See, that's not part of our issue in the case. So we're very tunnel visioned. In addition to all the cases we're having argued today, which is 6 cases, we also have another 12 cases that we're deciding and will conference, and we've been reading. So all of us have 18 cases in our mind at this point, and so we're focused just on the issues in those, and anything that doesn't relate, I've just set aside.
We operate on a need-to-know basis. We don't need to know that.
That's one of the reasons that we also strive to get our decisions done quickly, because this week we have been assigned our cases for next month. And if you let them stack up, it kind of becomes similar to Lucy and the Chocolate Factory. If you're familiar with that, it just becomes overwhelming because you have these old cases that you haven't completed the writing assignment while you have new ones coming in. And so it's just important to keep the process flowing.
Yes, ma'am.
I just had a question. One sentence in one of the briefs, it kind of talks to exactly what your role is, and that's what I'm trying to understand. I'm not sure I totally get it. It said, it is not this court's job to second-guess the legislature's decision-making process. Isn't that exactly what you do? I mean, I guess how they reach their legislation is not your question, but the constitutionality of that is your...
That's getting awfully close to the merits of the first issue that we addressed in the work comp case. I don't want to get too close to the...
I think actually...
Is it to question how they reach their decisions, or is it simply to question, here is law, this is how we interpret it?
Well, I think the statement actually is out of a Kansas Supreme Court decision that they're quoting, and it's a little bit tricky because it depends on the context. We don't generally question except when it's relevant to a constitutional issue like we don't generally question the reason for legislation. We question whether the legislation meets certain tests. So a legislature makes decisions not based on writing a research paper. They do take some information in, but then they vote. And voting is a compromise, and you have to take the end product and say, we know this end product was a compromised product that isn't the same as a research paper. Does it yet meet our tests? So we're not trying to micromanage the thought process that goes into something I think is the main point being made by that quote.
But your job is to check the legislature and say,
against the constitutional standard.
this law is not constitutional.
This is a kind of unusual case in that it was heard at the administrative level, and at the administrative level they did not consider the constitutionality because they don't have the authority to rule that a statute's unconstitutional. So all the normal findings that go into that kind of an issue were not made because and it came directly to us. It never got to the district court, the trial court. In the typical case that we see, the trial court conducts a trial or some sort of a hearing in which there are disputes over the facts. One side says A, the other side says B. The judge has to view the credibility of the witnesses and decide who's telling the truth and decides, I believe A. Then it comes up on appeal to us. We do not entertain arguments that that we should go back and revisit those facts and say, no, the judge, based on the credibility of witnesses, it should have been B, not A. We don't do that. We never saw the witnesses. The judge and the jury saw the witnesses in the trial. When they saw the demeanor of the witness, they saw that when the question was asked, beads of sweat broke out on the brow of the witness. His hands started shaking, and you get the picture. We don't get the benefit of any of that. All we have is a cold record, the transcript of what went on. So we defer to the trial judge and the jury on those kind of fact issues. Any other questions? Yes, yes, ma'am.
Someone's waiting for their appeal to go through, what happens to them? Like, are they incarcerated? Do they get to,
Well, if they've already been convicted, if it's a criminal case and they've been convicted and sentenced and have been sentenced to prison, they are in prison waiting for the outcome of their appeal, which may be either we can affirm it, in which they stay where they are. We could reverse it outright, in which may result in their freedom, or we may order that there be a new trial, in which case they're probably still in jail or maybe out on bail until there's a new trial.
Now, in certain situations, the district court has the ability to, and our court, to grant an appeal bond that would allow them to post a bond and remain out of jail. But that's rather unusual.
Yes, ma'am.
All 14 judges, how do you guys decide who hears what cases?
I decide all those things myself. No, that's not right. We have, excuse me, we have a staff that oversees the assignment of cases and puts together these dockets so that we basically try to even the load among the various judges. And every month we sit usually at a different place and hear different cases, and I will, last month I sat with neither of these judges, and next month I'll sit with somebody else entirely different too. We keep it mixed up.
Do we not seem mixed up?
And also our cases are graded in a process so that, which is not very accurate, but it kind of gives a guideline to balance the work so that if one judge doesn't get 6 A cases in 1 month, it's kind of balanced between A, B, and C. And then we're also blessed to have 2 research attorneys and a judicial assistant to help us in our office to get to deal with the volume of the cases.
An A case for us is not a really well-written case coming to us. It's one that we think has more difficult issues or maybe a really long, extensive record that we have to look at. So it'll take us more time.
Yes, sir.
When you guys are forming your interpretation of statute or of law or whatever, how do you remain unbiased, and what do you do when you guys have conflicting interpretations of the thing among each other?
How do we remain unbiased? We are not. We're like, look at jurors. We don't tell jurors not to be biased. We tell them to put aside their prejudices and apply the law as the court tells them. We're not so, we don't live in monasteries. We live out in the real world, and so we see what's going on in the real world, and we all come into the court with different ideas. But our job is to set aside those predetermined ideas and look at what the law is handed down either by the U.S. Supreme Court or by other courts, by our state Supreme Court, by other courts that we respect, or the way the legislature has adopted the law.
I would say it's impossible to set aside your entire life experience. And I would say that's one of the reasons it's unfortunate that we have a panel here of 3 old white guys with beards. You know, and I say that a little bit in jest, but it's in truth too. It's important that a judiciary be diverse because we do bring our life experience to bear. And while Judge McEnany says we are aware of what's going on, we're aware of it from our perspective and our life experience. And one of the great things on courts today versus the way they were 20 or 30 years ago is that we do have more women on the courts. In the state of Washington, a majority of their state Supreme Court is women. And that makes a big difference in the discussions you have when you go back, not because we bring a bias to play, but because you have a different life experience. On our court at the moment, we only have 3 women out of 14, and that's not really where it ought to be. We aren't in charge of the selection of our court, but that's, to me, kind of an issue. Also, age is an issue. Judges tend to be older, and therefore we may not have the life experience that many of you in this room have had. Our life experience growing up when we did may be different in significant ways that lead us not to be aware of things that would give us a different perspective. So I think we get this. We can't get rid of our bias. We can't get rid of all of our life experience. We can just do the best we can to try to understand everything in a fuller context, and having the most diversity among us does help us in that.
That's why, as old geezers, we don't do a lot of fact-finding. We leave that to the jury, and which is a broader reflection of the community at large. Any other questions? If there are none, we will be adjourned till 1:30. We invite you to come back. We have some interesting cases this afternoon, and you're certainly welcome, and we thank you for coming and being attentive.
All right.